Hello and welcome to another episode of A Tejswi IP Show. I am your host Prateek Raaj, and today we are talking about patent examination process. Filing a patent is just the first step. What happens next can determine whether your invention gets the legal protection it deserves. So let's break down what goes on after you hit submit on the patent application. Once you have filed your patent application, it goes through a detailed process before it gets granted or rejected. This process can be lengthy, so knowing the steps ahead of time can help you manage your expectations. The first major step is the formal examination. At this stage, the patent office checks if your application meets all the formal requirements, such as whether the correct documents are filed, fees are paid, and whether your invention is clearly described. So make sure your application is complete and error-free when you submit it. Uh, Incomplete or incorrect filing can cause unnecessary delays. Next comes the substantive examination. This is the part where things get really technical. A patent examiner, someone skilled in your invention's field, reviews your application to see if it meets the legal criteria for patentability. They will look for three things: novelty, inventive step, and industrial applicability. We have talked about these previous episode. Uh, so if you are new here, make sure to check out them out for a deeper dive into each criteria. The examiner will also search for any prior art, which includes previous patents, publications, or anything that proves your invention is already known. If prior art is found that covers your invention, the examiner may issue a first examination report, that is FER, explaining why your claims have been rejected. In many cases, the FER isn't the end of the road. You will have a chance to respond to the examiner's objections. This is known as the prosecution stage. You and your patent attorney can amend your claims to address the examiner's concern or argue why your invention is indeed novel and non-obvious. This back and forth can go on for a few rounds before the examiner makes a final decision. So I give you a pro tip. Be strategic when responding to FERs. Instead of completely narrowing your claims, work with your attorney to find a balance between addressing objections and retaining as much broad protection as possible. If everything checks out and the examiner is satisfied with your responses, your patent will move towards grant. Congratulations, you are now the proud owner of a granted patent. But the journey doesn't stop here. You will need to pay renewal fees to keep your patent in force. Depending on the country, these fees are paid annually or in a few installment over the patent's life. On the flip side, if examiner isn't convinced by your responses or if your claims are too broad, your patent could face rejection. If this happens, you can file an appeal or modify your application to better fit the examiner's requirements. Now let's talk about the patent examination timelines. In some countries like India, the patent examination process can take a few years. However, in countries like United States or Europe, you may be able to request an expedited examination if your invention is related to certain critical fields like technology or medicine. Just keep in mind that faster isn't always better. If you rush in process, you might overlook key elements of your patent application. So I give you one more pro tip. If you are in hurry, consider filing under the Patent Prosecution Highway Program, that is PPH program, which allows you to speed up the process if you have already filed in another participating country. Another factor to consider is the publication of your patent. Typically, patent applications are published 18 months after the filing date. This means the details of your invention are publicly available even before the patent is granted. While this can be nerve wracking, it also means your invention is protected from the moment it's published. After your patent is granted, you have the exclusive right to use, sell, or license your invention for up to 20 years, depending on the jurisdiction. However, maintaining this monopoly comes with responsibilities like enforcing your patent rights. If someone infringes on your patent, you will need to take legal action to protect your intellectual property. So, to recap the patent examination process, number one, formal examination. Ensure your application meets formal requirements. Number two, substantive examination, that is a technical review to see if your invention meets patentability criteria. Number three is FER, that is first examination report, in which issued if the examiner finds objections or prior art. uh, Number four is prosecution stage. You respond to the FER with amendments or arguments. Number five is grant or rejection. If successful, your patent is granted. If not, you can appeal or amend. And that's the patent examination process in a nutshell. It can be long and complex journey, but understanding each step can give you a better chance of success. As always, having a skilled patent attorney by your side can make all the difference. Thanks for tuning in, and that's all for the today's episode of this. Uh, if you have got any question about the patent examination process or want more tips on securing your intellectual property, drop us message or connect with us on social media. Keep innovating, and we will see you in next episode. Have a good day.